You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 123, What Shark Tank Entrepreneurs and Sharks Get Right and Wrong About Patents. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com, that's D-I-A-M-E-N-T, patentlaw.com, or call me at 424-281-0162. My guess is that most of my listeners here are entrepreneurs and that you probably watch the show Shark Tank. If you're not familiar with it, an entrepreneur makes a pitch to 5 potential investors called sharks, and they hope to get a deal with one of the sharks who will invest in their company in exchange, usually for some percent of the company. Not every entrepreneur's product can even be the subject of a patent. There was a girl, she had her own lemonade brand. There's not going to be a patent on her lemonade. If she's successful, it's going to be because her lemonade tastes better, or she's a better marketer, or has better distribution. And it's not because her lemonade is patented. So you don't need to have a patent to have a successful product. I want to repeat this. You don't need to have a patent to have a successful product. I probably tell half the people that contact me that they probably shouldn't get a patent. It could be for a variety of reasons. Maybe they want to patent something that can't be patented. Maybe they could get a patent on it, but it would be so narrow that it would be easy for people to design around it. Or maybe the success of their product isn't going to be that it's patented, but they're better marketers. Or maybe I just tell them that the cost of what it will take to get a patent, it's better for them to just use that money to do something else with it to increase their business. And if someone happens to copy them, then so be it, but you'll have saved some money by not trying to get a patent, and you'll be successful because you were first to market or for some other reason. So what does Shark Tank get wrong about patents? I'm actually going to attribute this to the show being highly edited, and they just don't have time to go into all the details of patents. And they probably do go into all these details, but it's probably just not part of the show. They'll ask if the entrepreneur has a patent on their product, and the entrepreneur says, yes, I have a utility patent. Now, rarely is there follow-up to this question, which is, what is it that you exactly have a patent for? If they have a product with 15 parts to it, can someone essentially make the same thing, remove one unimportant part, and then just essentially copy your product? I have no idea, because they hardly ever say what the patent is for. That's my biggest complaint. My guess is that behind the scenes, they might go more into this, but I have no idea what the patent is for. I had a client come to me and said they want to copy a product, but the packaging on the product said that it was patented, and they asked me if they could copy it. I told them I have no idea. Maybe it's not the product that's even patented. Maybe they patented the packaging, and there was some new packaging they came up with, and that's what the patent's for, and it has nothing to do with the product. You just can't tell without actually looking up the patent number and seeing what the patent covers. Another pet peeve of mine, and every other patent attorney I know, is that when someone says they have a provisional patent on something, there's no such thing as a provisional patent. There's a provisional patent application, but the application doesn't actually turn into a patent. The provisional patent application never gets examined. I can submit a provisional patent application for a pencil, and then I could say all pencils are patent pending, and I have a provisional patent application on file. So what? First, the provisional application never gets examined, and if it did, it would never get allowed. So if someone says they have a provisional patent application, or even a non-provisional patent application on file, so it's patent pending, it doesn't mean anything to me, because I have no idea the odds of whether it's going to actually get a patent or not. Another thing I see is that someone says they have a design patent for something. A design patent protects the look of a product. So when someone goes up and they have a product that has a specialized function, and they say they have a design patent for it, often I'll also just say, so what? Someone can just make the exact same product, just have it look different, and they're not infringing. I rarely hear the sharks make that comment to the inventor. Now, design patents can be useful. One of the most successful products on Shark Tank was Scrub Daddy. If you haven't seen it, it's a sponge that has holes that look like a smiley face. Part of the allure of the product is that it looks cute, so a design patent is useful there. Now, not only do they have a design patent for the look, but they also got utility patents for the material and process for making the material and the scouring pad of the material. So they really covered their bases with both a design and a utility patent. But if they didn't have a utility patent, I really think that people are buying it because it kind of looks like a cool sponge. Now, some of the sharks in Shark Tank appear more patent-friendly than others. Mr. Wonderful will ask if the person has a patent, and if they say no, he says, what's to stop one of the big competitor companies to just copy it and crush you? It's a good question, But it's a question and not a statement that it will happen, but it's a good question to ask. Maybe the answer is, yeah, they might copy me, but by the time they figure out how to do it and get it to market, I will have made $10 million already. Mark Cuban is known to be more against patents. Lots of times he'll make comments to the effect that he doesn't care that much about patents, and he's actually anti-patent in many cases. And it's not the patent that's going to make the business do well, but other aspects of the business. But when push comes to shove, he was threatening to sue Walmart for infringement of a hoverboard patent, where he invested money in a product that was patented. So there's nothing wrong wanting to protect an investment that you have a patent on, and no doubt there are abuses of the system, but it's convenient to like patents when you're holding one and not like them when you're on the receiving end of a lawsuit. So what does Shark Tank get right about patents? Very occasionally, there will be a discussion about specifics about patents, which is why I think my criticisms of what they get wrong is probably just due to editing. There was an episode where someone had a product called Coolbox. It's season 7, episode 23, if you want to watch it. And it was a toolbox, had lots of things. It had wireless Bluetooth speakers, USB ports, power ports, a whiteboard, a light, 2 iPad and iPhone stands, magnetic lid, bottle opener, a clock, and a few other things too. This is a classic example of when someone says they have a patent on something with lots of parts, what is it that they actually have a patent on? First, Lori asks if they have a patent, and the guy says, yes, we have a provisional patent. That's the first thing that should set up alarm bells. There's no such thing as a provisional patent. Then Robert asks, what's the patent on? And the guy says, it's a utility patent on all the features combined. And Robert says, so no one can put Bluetooth speakers on a toolbox? And the guy says, it's a combination. The Bluetooth speakers, the USB ports, the lights, the magnetic lid, iPad stand. The inventor is probably thinking that by listing all these things, he's making his case for how good his protection is. But what he's doing is actually the opposite. He's saying how easy it is for someone to just knock it off as long as they remove one of those features. Then here, Lori is actually very astute in asking some good questions. She says, let's say someone makes a toolbox that doesn't have a magnetic top, but has speakers. The inventors say, well, at the end, we're building a brand. And Robert says, well, how are you going to license it to Black & Decker? They're going to rip it off in a second. Their response was that they're already in discussions and they have the ability to create and shift with newer innovations, and they'll be first to market. Some of the other sharks like Damon see this as a licensing deal, but Mark points out that a licensee is going to want complete patent protection. And Mark says that his lack of confidence is that there's nothing protectable. You know, I get clients coming in all the time and they want to combine things and say that the combination has never been done before, so it should be patentable. Well, that's not how it works. Go back and listen to my episodes on obviousness. If you have 2 or 3 things in a product that work exactly the same way as they do individually, as when you put them together, then it's hard to get a patent on it. So a flashlight, Bluetooth speakers, and a toolbox. Let's just take those 3 things. The flashlight is just acting like a normal flashlight. The Bluetooth speakers are just acting like normal Bluetooth speakers. The toolbox holds tools like any normal toolbox. Put them all together, and everything is just working exactly the same way as they worked individually. When this is the case, it can be hard, but not impossible to get a patent. And maybe if you put 20 things together, you have a better case to get a patent. But at the same time, if you're requiring 20 things to get your patent, it just makes it easier for someone to design around it by eliminating one of those 20 things. Now, in the end, they ended up getting a deal, but it wasn't that great of a deal. I don't know the entire story, but the product is still around. But they did create a cheaper version of it compared to what was presented on Shark Tank. So I commend Shark Tank for putting in a few more details about the problem with normally just saying that, you have a patent on something and then not following up. And there's probably a lot more that goes on behind the scenes. But at least for this episode, they had some follow-up questions on what patent protection would and wouldn't do. I read an article online that the device-based products on Shark Tank, about 77% were patented or patent pending. And of the products that got a deal, about 81% were patented or patent pending. And the ones that didn't get a deal, 61% of those were patented or patent pending. This article was a few years old, and there might be some correlation doesn't equal causation here. But a really simple reading is that having a patent or patent pending on a product has some value in terms of whether you're more likely to get a deal with investors or not. So there's no negative except for the cost to at least get an application on file with the patent office. So at least you can say that it's patent pending. But understand that patent pending isn't a patent. You don't have any enforceable rights until your patent issues. So know that there's value in getting a patent, but you can be a successful entrepreneur without getting one, and you can be an unsuccessful entrepreneur even with a patent. And you just have to weigh the costs and benefits of how much it's going to cost, the likelihood of getting a patent at all, how broad or narrow your protection will be if you do get a patent, what you might do with the money you save if you don't bother applying to get a patent, or the money that you won't make by not getting a licensing deal because there's nothing for you to license if you don't have any patent protection. So those are just some of my comments on Shark Tank and patent protection. If you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.